Hence, as we would notice that with the case of the official liquidator to be determined as a public authority, and further on to look at whether the Attorney General's office is a public authority or not, as we see that as we currently look at this course, the Supreme Court has not finally put a word on whether the AG's office is a public authority. However, from my perspective and from my interpretation of the Right to Information Act, though there are practical difficulties of establishing the RTI regime, we cannot exclude the AG from the accountability perspective of the Right to Information Act. It's not necessary that the AG's office is in particular declared as a public authority. However, the AG's office shall be amenable for providing information under the Right to Information Act. Yeah, the practicality of who shall be an appellate authority. The appellate authority to the AG's office can be the law minister or the law ministry, can be at the Prime Minister's office, or can be at the President's office as well. That's not the issue in terms of saying the AG's office should not be brought under the RTI Act. I think the AG being paid by the government, the AG being accountable by the government, the AG representing the government, he is another organ of the government in terms of the first law officer. And hence, despite it being a law office or a lawyer's office, should not in any way exclude the AG from the purview of the Right to Information Act. And hence, from my perspective, the AG's office is to be brought within the RTI regime, and the AG shall be held accountable to share information that is disclosable and that is permissible. And that's why anything that he represents the government, or anything that is relevant for the citizens to hold the government accountable vis-a-vis the legal proceedings in which the AG is involved, I think the Right to Information Act should squarely apply on the AG's office. When I say AG's office, I mean the Attorney General's office at the central government level and the Advocate General's office at the state government level as well. So I think the Supreme Court must clarify and finally settle this matter as soon as possible, and should settle the matter in the positive spirit of the legislation and the purpose behind which the Right to Information Act was enacted. Going further, if we look at the test, control test, which is applicable to public authorities, because government control on certain organizations is very important and relevant. Interestingly, the case of the Gujarat Information Commission deciding in this Dilip Singh Jalwa versus APMC, this case spoke about what are the role of the cooperative movement in India. As we know that the cooperative movement has been very strong. It has contributed enormously in the housing sector, in the banking sector, and in the producers' cooperatives are doing pretty well in food grains, in the supply chain, in milk production, in dairy, and so on and so forth. And hence, many of the cooperatives have government support, government control as well. And very often than not, the government has officers working for these cooperatives nominated, and these cooperatives have a law for themselves as well. And hence, the pertinent question that is to be asked is, can information be sought from the cooperatives as well? Now, in this case, the Gujarat Information Commission did say that if the cooperative is controlled by the government and if substantially financed by the government, then to that extent the cooperatives must be brought within the purview of Section 2H of the Right to Information Act. So, disposing some nearly 28 complaints and appeals, the Information Commission in Gujarat in 2005 clearly held that cooperatives are accountable and should be brought within the purview of the Right to Information law. Similarly, the Delhi High Court in this Krishak Bharti Cooperative Limited case has held that multi-state cooperative societies, you will notice that multi-state cooperatives are those that are registered under the Multi-State Cooperatives Act of 2002, and they may have their operation in more than one state, and hence that's why they are called the multi-state cooperative. Those cooperatives who come under this act and who get registered under this act should be brought within the accountability of the Right to Information Act, is what the Delhi High Court held in this case. And hence, similarly, the National Cooperative Consumer Federation of India and the National Agricultural Cooperative Federation of India. So the Consumer Federation and the Agricultural Cooperative Federations, which are supposed to be the multi-state cooperatives that are there, these were held to be public authorities under the Right to Information Act. Now, while we look at the control test as applicable to cooperative societies, one must be cautious here. And the caution is that, remember, while these three judgments definitely bring cooperatives under the RTA regime, it should not be a blanket test, and it should not be a test in which you paint the brush of RTA on all cooperatives. I think there are certain cooperatives that may be registered under the Cooperatives Act, but will not have probably any control or any finance from the government. It's not necessary that if agency has been registered as a cooperative, it is controlled and funded by the government, right? So I think if we say cooperatives are controlled, in that sense, then every other business in India is controlled by the government. That alone, I think the control test alone should not be the test in which the Commission or the High Court must determine an agency to be a public authority. I think the control test, if solely applied to agencies without the test of ownership and finance, will be misleading. Because in India, I don't think there is any business that is not controlled by the government. There are companies that are controlled, there are cooperatives that are controlled, there are societies that are controlled, there are banks that are controlled. So every other activity, I think, is controlled by the government in some form or some way. And hence, it would be difficult to apply the control test as the single test for applicability of Section 2H for institutions. However, at this point of time, I would definitely want to clarify and state that, in my view, the control test is a different test than a regulation test, because the government does regulate different activities, whereas when it tries to control, it takes management control, it takes control of the way the day-to-day functioning of an organization is to be administered. It definitely guides the day-to-day functioning, and this control can only be done if the government has ownership. The government is able to nominate officers who can work for the organization, and the government can actually guide the directions given by the government also adequately funds such organization. So in those instances, I'm sure one would appreciate how the test under Section 2H must be applicable to such cooperatives and to such organizations. The next aspect for our discussion under the aspect of public authority is the status of non-governmental organizations. Now, I'm sure you all are quite aware of NGOs or non-governmental organizations. Please note, they are called as non-governmental because they are not government and they are non-state. However, when one has looked at Section 2H, it clearly stipulates and states that non-governmental organizations also come within the purview of the Right to Information Act, provided they have been substantially financed by the government, right? Now, the reason, even though you're not established by the government, even though you are not controlled or owned by the government, if you're funded by the government, then there needs to be accountability, there needs to be transparency, there needs to be a system where citizens can demand information from such organizations. And that is the reason and the purpose behind why NGOs who receive funds from the government are also brought within the purview of the Right to Information Act. Now, let us look at some of the cases or some of the instances where this test has been applied, and what kind of NGOs were either brought into the purview of the Right to Information Act or probably were not brought into the purview of the Right to Information Act. If so, what reasons were provided in those cases. This first case is a case of Suman Bakshi versus Directorate of Health Services, Government of NCT, Delhi. And the single issue in this case was whether the Family Planning Association is a public authority or not.